Melissa Alloway here. Are you here for Are you the victim, right?
Yes.
This is another one I'd like you guys to iron out. I want to call in the prosecutor again. I'm sorry.
There's a victim on Zoom also.
Okay, yeah, Mr. Lamphere, right? All right. Good morning, Mr. Alloway. Your name?
Hello, can you hear me?
I need your name, sir.
Yes, Your Honor. Issa Holloway?
Where's your lawyer at? Is he with you?
Yeah. He's,
Well, I need him. Where is he? Mr. Lamphere, your name?
Chris Lamphere.
Sir, your name?
Pietro Battalion.
Your name again?
Good morning, Your Honor. Muhammad, the prosecutor.
I got everybody here. Where's your lawyer?
he said he's in the waiting room.
Okay, you got to bring him out of the waiting room. I adjourned this sentence from October 21. Let me just wait until he gets in here.
Judge, he's not on Zoom.
I don't know.
I'm sorry, sir. Your name again, sir? Sir,
Yes.
your name again?
Pietro Battalion.
Okay, I just wasn't sure which other one you were.
He's out there now. I brought him in.
Counsel, I need you in here, please. Yep. There you go. Your appearance?
Abdullah Mugni, P number 85374 on behalf of Issa Holloway.
All right, I have Mr. Vitale as the victim. I have Mr. Lamphere as the victim. Another victim signed his letter by the name of Mark, signed his name to the restitution letter by the name of Mark Gardner. You guys said it looks like there was an agreement of restitution for $1,000. The victims here are asking for all kinds of money. They got $6,250 plus disposal of $300. That makes $6,550. They got economic loss of $1,980 plus $220 per month until restitution paid. They're claiming economic loss.
Yes. So, Your Honor, since the last hearing, I had the opportunity to speak with the prosecutor on the co-defendant case, which is in juvenile court. And my understanding is full restitution has been paid in regards to the $6,250. The remaining balance of the $300 for removal of the items from the location, that's still remaining. I've spoken with defense counsel and we are now stipulating my understanding of $300. So restitution has to be only out-of-pocket expenses sustained by the victim. Anything more we can't do. I've explained it to the complaining witness that economic losses is not something that we can receive as part of a criminal case, only out-of-pocket expenses. And since $6,250 has been completed in the co-defendant case, the only remaining balance is the $300. I understand that defense had paid last time an amount of $1,000. We were just requesting that $1,000 be amended to $300 so that the victim or complaining witness can now be made whole.
Do you understand and agree to that, you and your client, Mr. Mugni?
That is correct, Your Honor.
I pronounced that correctly, right?
You nailed it.
Good. You understand that, Mr. Alloway?
Yes, sir.
You agree to that?
Yes, Your Honor.
Okay, we got a little problem with the recording. Just bear with me 1 second.
Going to get which in the recording stopped. I was doing still recording. So I stopped it. And then I did something that stopped it. So he's wanting to make sure it's recording. Testing 1, 2, 3. Maybe turned it. I turned it off and turned it off. Thank you. All right, Judge, let's try again.
Okay. Is that working so far? All right, so we're still on record here. I want to make sure that the prosecution has explained that to you, Mr. Vitale.
Yes.
Do you agree to that?
Yes.
Mr. Lampier, do you agree to that?
Yes.
So you understand, first of all, I want to make sure, did the three of you receive the $62.50 that was paid on the other case?
We
It has not been received yet, but we-
Hang on, wait.
I'm sorry.
Only one at a time. Who wants to speak?
We'll let Pete.
Go ahead.
We haven't physically received it yet, but we understand from the juvenile court that it is on the way.
Okay, so they've received it.
Yes.
So you're agreeing to the restitution here in the amount of $300. Is that correct?
Correct.
Who are we going to make that? And you agree to that too, Mr. Lampier, true?
Correct.
Who is going to be the recipient of the check? Are we going to send it to all three of you? I would suggest we send it to you, Mr. Vitale, you, Mr. Lampier, and Mr. Gardner. Any problem with that, Mr. Lampier?
No problem with that.
Problem with that?
No.
And Mr. Gardner, just to be clear, is not here, correct?
He said he's in the waiting room, but hasn't been let in, but I'm not sure. He has technical challenges, so I'm not sure he's in the right waiting room.
See him out there, Lisa?
I'm sorry, who was it?
Mr.
Mark
Mark
Gardner.
Gardner?
Oh, yep, I messaged him to see who he was and he didn't respond.
Okay, bring him in too,
I'll bring him
please.
in.
So let's just take our time here, and then the victims can say something.
Judge, it looks like he's on, but you might want to ask him to turn on his camera.
Oh, Mr. Gardner, can you please turn your camera on for me, sir? You have to turn your camera on from bottom left-hand corner of the screen. There you go. Tell me your name, please.
Mark Gardner.
So I want to make sure that everything I just heard, you weren't in here. I didn't think you were here. Next time when you come to court, if you ever do on Zoom again, you have to have your name by your device or underneath your picture there, for the reason that we have to know who you are. We don't know that Motorola is Mark Gardner. But at any rate, I was just told that on another case related in juvenile court, that $6,250 was paid to the juvenile court, and that you and Mr. Lampier and Mr. Vitale are going to be the recipient of that. And everybody seems to agree, and I want to make sure you do, and if you don't, tell me, that the restitution now on this case, instead of $1,000, will be $300. Do you understand that, and do you agree to that?
Yes, Your Honor.
All right. Now, I'm going to let you guys speak if you would like. I'm going to ask Mr. Mugni, have you had a chance to review the pre-sentence report, and are there any material additions, corrections, or deletions?
I reviewed it with my client, Your Honor. There are no needs for corrections or additions.
Right? Anything that you would like to say on his behalf?
Yes, Your Honor. So I've gotten the opportunity to get to know Issa over the last month or so, and he's a good kid. He's a God-fearing, respectful young man who comes from a very good family. He has strong ties. His father has come with him to every meeting in my office. His father has shown up to every court date. Even now, his father is waiting for him in the office, waking up bringing him to our court at 8:30 a.m. for the numerous times that we've been here. My client, he's not a bad guy. He's a good kid in a bad situation who made a mistake trying to impress some not so good friends. And that's how we ended up here. My client was born with a birth defect, a disability called Stuve-Weidman syndrome, which causes him to have deformities in his bones. This has put him in a situation where he wants to fit in with with his friends. He wants to fit in with his friends, which led him to do these wrong acts, which he is sorry for. He feels awful about. He wants to get on the right path. This was a one-off mistake. He was given a good deal, which allows him to clean this off his record and start from scratch if he does everything correctly. He greatly apologizes to the owners of this facility. I know you're all here, and I want to take a second to apologize to you all for my client's and his friend's actions. This was a one-off mistake. It's not his character. It's not something that he does. He was in the wrong, and he fully admits to being sorry for what he did. So we
How long
apologize.
how long was he in jail on this?
3 days, Your Honor. Or no, sorry, one night. My apologies.
One night.
Yep.
All right. I'm sorry, I cut you off. My apologies. Anything else?
Yes. So I know that brother counsel, the prosecutor Muhammad, he ended up saying that we paid $1,000 last time. That was supposed to be held as bond just so my client wouldn't have to come back. He did pay that in full. So with the $300 that is going to go back in restitution, we ask that the remaining $700 be applied to any costs and fines. If your costs and fines are going to be over $700 in excess, my client is indigent. He's asking that he be given extra community service if you believe that the money needs to go above it, as he has no more money to pay.
Thank you. Anything you would like to say, Mr. Alloway?
No, he said it all for me.
Be a leader, not a follower, Mr. Alloway.
I'm sorry about all this. Like,
I understand. Well, we make mistakes, and this was not a little one. It was a bigger one. Let's make sure you don't make any more.
I'll never.
Be a leader, not a follower. You could have been saying we shouldn't be doing this, breaking into storage units and everything else that goes along with it. So really, use your head going forward. Mr. Vitale, would you like to say anything?
No, I'm just glad that it's behind us now.
Mr. Lamphere, would you like to say anything?
I do appreciate the apology. Issa, watching the event happen, you seem to be the leader in it. So even if you were trying to impress your friends, impress them with good rather than bad. And it sounds like that's the path you're on, and I'm happy to hear that.
Thank you. Mr. Gardner, anything you would like to say?
No, Your Honor.
Anything, Mr. Muhammad?
No, thank you.
12 months probation. I'll be happy to take it under HIDA. That was the agreement. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. You would attend the impulsive behavior program through Class A Training Center. Attend that, complete that. Probation will explain that to you. You're also to not have any contact with Mark Gardner, Pietro Vitale, or Chris Lamphere. You're not to enter or go near 24400 West Jefferson in the city of Gibraltar, County of Wayne. You're to serve 5 days jail credit, 1 serve 4. I'll let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that, for a total of $105, and 1 day of community service. So 5 days jail, but I'll let you do 3 days court work, 1 day community service. That's at any nonprofit organization of your choosing. You have until December 20 to complete your community service. They'll schedule you on the court work program. In terms of in the check, we're going to make sure, Lisa, if you can make a note, the check, I'm ordering $300 in restitution. That's to be made payable jointly to Mr. Vitale, Mr. Lamphere, and Mark Gardner. $200 in fines, $200 costs, $75 victim's rights fee, $50 justice assessment. That's 5 1/4. Screening fee 60 for 585. Probation fees are $240 for a total of $825, plus the court work program fees. Everything included amounts to $930. Now, I don't mind giving him time to pay. I believe I said $1,000 cash bond. So
Judge.
that should cover everything except $230 of restitution, counsel. So I'm just going to give him time to pay that. I'll give him until, can he? What, just tell me, I know you said he's indigent, but when can he just pay that by? Why is he not working, counsel, by the way?
I think he gets paid through the state for disability.
Okay. Lisa, the bond's in his name, right? Yes. Can you pay this anytime, Mr. Alloway? Can you go to somebody and get $230 and we'll be done with it?
Oh, yeah, I can.
Can you pay this by November the 10th? That's next week.
Yeah.
So you'll have to pay another 200. So I'm just going to indicate you're going to pay 1,000 now. And then the balance by November the 11th, which will be $230, because including the restitution, it comes out to $1,230. Okay. You're going to meet with probation counsel. Will you call 671-0201 extension 245? See when they can come in and get him, or when he can, when it's best for him to come in. And I want a review hearing date as well, Lisa, please, in a year. And you come back then. If there's no problems, this case is going to be dismissed if you've complied.
Yes, Your Honor.
October 20th of 26 at 9 o'clock.
So October 20th of 26 at 9.
Yes, Your Honor.
The court is closed on the 11th, so you just might want to let him know he has to.
Oh, yeah. Thank
That's
you.
Veterans Day.
Court is closed on the 11th, so I'll just give you till the 12th. You can't bring it in on the 11th. We won't be open, okay? But you could pay online on that day if you wanted. So
All right.
I'll give you till the 12th, Wednesday. So call that with area 734, Mr. Moogny, and they'll tell you when he can come in. Anything, any questions, Mr. Vitale, Mr. Lampier,
No questions.
Mr. Gardner,
No questions.
Mr. Moogny?
Yes, just to make sure I got the number correct. That's 734-671-0201.
Extension 245. So as soon as that comes on, you can say, you just punch in 245 and just ask them when they want them to come over. Okay? Good luck. You should have your money soon, whatever's left, but we're going to probably wait till we get all of it, okay?
Thank you, Your Honor.
Have a great day. Thanks, you gentlemen. Have a good day. Thank you very much. Good luck,
Thank you.
sir.
Thank you.
Derek Robert Wormers, 25 S5 73869 A and B. Good morning.
Good morning, yeah.
How are you?
Good, you?
Good, thanks. Your appearance?
Yes, I'm with the
Right.
Derek Warner, Corporal Casey Vega with Wayne County Sheriff Road Patrol.
Mr. Wormers, you're gonna have to start your video, please, and state your name.
My name is Derek Wormers.
Good morning. So he's charged with no proof of insurance and expired plate. Any offer on this?
Not that I'm aware of. The prosecutor offered him.
Well, this is just an informal, so it's up to you. Do you have your registration?
Yes, I do. I have my registration and proof of insurance here with me.
You want to, and you just renewed those? You didn't have them at the time?
Correct. I ran into some financial
Okay.
hardship and I kept pushing
Okay.
it off.
Okay.
But it's done.
Do you want any offer, or you want him just,
If he has everything updated, I'm good with it, Your Honor.
well, I gotta have him plead to one at least. I mean, but if you want to dismiss, the problem is he had an expired plate since May of 22. I mean, you can't go 3.5 years without. So how about he pleads to that? Let me see your documents, please. I gotta see your insurance and your registration. Okay, now look, I'm getting old. You gotta get it up there nice and,
Okay.
I'm not getting old. I am old.
Okay. Can you see it or need me to adjust it?
No, I can't see a thing. I can see a wall, it looks like.
Okay. I'm gonna switch the camera so I can. Okay. Settings. I'm gonna try to flip the camera, but I'm not sure how to do that because perhaps I am just as old as you.
No, I don't think so. Nobody's as old as me, unless you're in Social Security and Medicare already.
Okay. There we go. I think I got it. You can't even see me now, can you?
I don't need to see you. I need to see a close-up version of that registration and the insurance.
Yes, I have got them both right here. I'm just trying to get rid of the background so we can see it.
Is it easier for you to take a picture of it and send it to my judicial clerk by email?
I hope so. I really apologize. I'm not super familiar with Zoom.
Well, that's okay. Don't worry about it.
All right, I don't know how well you can. It's got this background on it. That's why. Okay.
Wait a minute. Just keep it right there. Keep it right there. Oh, geez.
Is it up a little bit?
Yeah, tilt it up a little bit. Can either one of you see that? Oh, that's a little better. Okay. Now move it over just slightly to your left. Now up just a little bit. Okay, wait.
Get it closer.
No, move it over to your left ever so slightly. I want to see the date that was renewed. What does that say? Can you guys see that?
It'd be his right, I think.
It was. I renewed it. I will tell you, I renewed it yesterday. I had.
That's
to
what
go-
I thought. That's what it
Yep.
looks like. Okay, now let's see your proof of insurance.
Okay.
Well, you couldn't have got a plate unless you showed them insurance. So I'll tell you what, we're going to take your word for it. I believe you. If you
Okay.
plead the expired plate, he's going to dismiss the no proof. True? Okay, is that what you want to do?
Yes,
To the charge expired plate, responsible or not responsible?
responsible.
All right. I'll accept the plea. Mr. Wormers, where do you work now, sir?
I work at Advance Auto in Trenton, Michigan.
Okay, so you're doing okay. 135 is your total. I'm going to go ahead and dismiss on motion of the officer. The no proof, 135 on the expired plate. You can pay that today?
Can I break it into maybe like 2 payments?
Yeah. How much can you pay today? Just tell me when you can pay it.
Can I do 50 today?
Yep. And when can you pay the rest?
Next,
How about November 17th?
it's
It's
a couple weeks from now. Yes, okay,
It's 2 weeks from yesterday.
that's fine.
All right. So you pay 50 today, the rest by November 17th. If somehow you don't have the money,
Mhm.
no problem. Call the court. We'll go on Zoom on or before the due date. On or before the due date. I'll be glad to give you an extension. I don't care how many times we have to do that. Okay?
Okay, thank you, sir.
I wish you well. Good luck to you. Thank you very much. You can use 33court.com if you'd like. Thanks a lot, Corporal.
Thank you, Your Honor.
Joshua David Ramon Williams Brown, 25M607006A. Come on up here, sir. And B and C, right up to the podium. Your name?
Jeff, no problem.
You see, they can't really do this. Call in the prosecutor for a sec. You're charged with operating a vehicle without insurance. That's a 1-year misdemeanor. The problem is they cannot issue a citation where it's punishable by up to a year. So technically, they have to reissue this case. You also have a defective equipment brake lights and the expired registration plate. Okay? You have the right to a lawyer on these. If you cannot afford, either way, whether you can afford one or not, I'm going to give you one. Do you want a lawyer?
Yes.
All right, we'll give you a lawyer. You can tell the lawyer what I said, but technically, they can't issue a citation and charge the 1-year misdemeanor, and that's what it appears he did, okay? So we'll give you a court-appointed lawyer, go out in the hallway, and then either way, you'll come back in front of me, okay? Thank you. So here's another one that I'm getting concerned about. Joshua David Ramon Williams Brown, 25M607006A.
Good morning
And B
again.
and C.
Well, Good afternoon, Judge and staff. John Gus, anything.
So they're charging a 1-year misdemeanor, counsel, with the your name?
Good morning, Your Honor. Mohammed
Somebody has to talk to them. They're writing these no insurance like they're no proof of insurance. I mean, they're citing the misdemeanor statute, but they're just writing. They're charging a 1-year misdemeanor by issuing a citation, which, as you know, is inappropriate. So they're going to have to go to you. In the meantime, your name, sir? So I mean, I don't have a problem with taking this plea. He's going to plead to no proof of insurance as it relates to count 1, right, Mr.
Yes,
Graziani?
yes, sir. Yes,
And then, let me just double check something. And he stands mute and waives formal reading on that, true?
that's correct, Judge.
So we're going to dismiss the original charge once he pleads to no proof of insurance, and then you've also got him pleading to expired registration, commercial vehicle file 2. And then what happened with the defective equipment?
Your Honor, I was informed that in regards to the defective equipment, that was already taken care of. So
What do you
the
mean?
defendant will be pleading responsible for both the civil infractions. In regards to the defective equipment, I was informed it was taken care of.
Is that right, Lisa? Did he get it? Did he get the defective? Did you pay that?
It's not paid.
That's still in effect.
Excuse me, Judge. It was my understanding that, it would be resolved today. I didn't realize that had to be paid separately. I wasn't aware of that, Judge.
Well, I don't know what you mean by that.
No, I thought that they dismissed it, and as a result, he was not responsible for.
I don't care if they dismiss it.
No,
or
I
pleads to it.
wasn't dismissing it. I was informed that it was taken care of, which I assumed meant he had paid that citation.
And we,
I'm sorry, my understanding was that he had taken care of the actual defect that existed. That's my mistake.
well, he's got to have somebody sign off and bring it here. And this was,
Understood, Judge.
the officer, I don't know what kind of, this is brake lights. We don't have any proof that it was taken care of. It's up to you guys what you want to do with it.
I would agree, Your Honor, that if it's been taken care of and there's full compliance with the law, we would dismiss it as part of the resolution.
So the issue is the red brush light, not the brake light.
Well, he wrote brake lights.
You broke brake light, brake lights were absolutely
Okay.
fine.
Present this, Judge.
I don't,
But in
I'm,
the interest of justice, I'll move to dismiss
Wait.
the defective equipment.
will you add that on here, please?
Yeah.
So he's going to plead to a commercial vehicle expired plate, and your client's going to also plead to no proof of insurance. Prosecutor will move to dismiss the misdemeanor of no insurance and the brake lights, right?
Yeah,
The
the
fact that
brake
he-
light is a civil infraction.
Right.
Yes.
Is that what you want to do?
Yes, we do want to do that, Judge.
Okay, sir, to the charge, no proof of insurance, responsible or not responsible?
Responsible.
To the charge of expired commercial plate, responsible or not responsible?
Responsible.
I'll accept those pleas. I'm going to go ahead and dismiss count 1, the misdemeanor of no insurance. I'm going to also dismiss count 2. Lisa, can you pull up and tell me what our chart lists on expired plate for commercial vehicle? I can't remember if it's 235 or what it is.
235.
Okay, so that's what I'm going to find you, sir, on the expired plate, commercial vehicle. I'll tell you what, do you have insurance now?
I don't drive the vehicle.
Well, you can't drive around a commercial vehicle without insurance and plates and everything else.
Judge, in his defense, he was unaware of it, and nor does he own a vehicle at this time.
Okay, 185 on that one, so your total here is $420. Can you pay that? How much you have today? Where are you working?
We're getting GM. I got let go for overtime a few months ago.
Oh, geez. All right, I'll tell you what, you pay $40 now on the no insurance. When can you pay the rest of that? That balance would be $145. Can you pay that by December the 2nd?
Honestly, I don't know about the job.
December 16th. There's all kinds of jobs out there. I know you look like a hardworking guy. You're gonna pay that by December 16th, and you're gonna pay the 235 on the other one by.
Judge, for the record, he has indicated to me he is a registered sex offender, and as a result, he does have some issues. But nonetheless, we appreciate the accommodation.
All right, just January 16th, you're gonna pay the commercial plate. Listen to me. Listen. And you're gonna pay the other one by December 6th, December the 16th. Now listen very carefully. You don't have the money. It's not a problem. Just show me some courtesy and us courtesy and call the court on it before the due date. I'll be glad to work with you. Okay? I don't care how many times we have to do it, but you need to go find yourself some work so you can eat. I don't know how a lot of people can eat when they're not working. They can't eat. They can't put a roof over their head. They don't have a car. They don't have insurance. They don't have gas, right?
We started the garden.
Started a garden. That's good. What do you have in the garden?
Berries, corn, carrots,
Nice.
potatoes.
Nice. Good. Who's we? All right. Well, good luck to you. I wish you well. Again, if you need time, just don't hesitate to ask. I promise you, I'll give you all the time you need. Don't ignore me. I hate that. Good luck. Is Ms. Belcher out there, Lisa?
She's coming in right now.
Still everything.
People against Colby, Richard, Ferguson, 25B, 725-812. Good morning, Mr. Ferguson. State your name, please. Good morning, Ms. Belcher. Your appearance?
Good morning, Your Honor. Leanna Belcher on behalf of Mr. Ferguson.
Where is Mr. Ferguson right now?
Your Honor, he should be on Zoom. He and I have had multiple phone conversations. I did confirm he had the Zoom information for Your Honor.
Okay.
I can reach out to him again if.
Yeah, he's
there
on
he
there
is.
right now.
He
Mr.
was just
Ferguson,
stuck.
Mr. Ferguson, start your video, please. Ms. Oro, unmute and state your name.
Yeah, good morning, Your Honor. Madison Oro on behalf of the people, PA 8398.
Mr. Ferguson, start your video and unmute. There you go. Unmute now, please, and state your name then. You have to unmute on the bottom left-hand corner of your screen, okay?
Yes, my name Kobe Ferguson.
Good morning. Okay, so today is the date scheduled. Okay, so today is the date scheduled. Where am I getting the?
Your Honor, I think it's feedback from Mr. Ferguson's device.
Yeah, it is. Can you turn that down a little bit?
Yes.
All right. What do you guys want to do on this? Today is the date scheduled for probable cause conference.
Your Honor, we're requesting to set a preliminary examination date. We would be requesting the 25th of this month from Your Honor. We certainly understand that that's a bit further out than Your Honor typically likes to schedule things. However, due to the nature of the charges and the fact that I have not received any discovery,
I don't have a problem with that. Do you guys, it does not have to be a Tuesday, by the way. If you guys want to do it another day, I'm fine with that. If you want to do the 25th, I'm fine with that.
Your Honor, we only discussed Tuesdays. I didn't think because this is a special prosecutor that we could do another day.
Ms. Oro, you are not driving, right?
Your Honor, I am driving.
Ms. Oro, I'm not going to conduct anything with anybody if they're driving.
Okay, then
Well,
I just need a minute, Your Honor. I've been waiting for a while, so I do just need a few minutes if that's okay.
I'm going to be conducting hearings with lawyers on boats and laying on beaches in Hawaii before we're done. You know that, Ms. Belcher, before I leave this bench?
Well, Judge, at least you'll be able to say you've seen it all.
Well, I've already gotten to that point, to be honest with you. whatever.
Oh.
Can I bring an iPhone while we're waiting?
Absolutely.
They won't answer my messages.
Does anybody read those instructions we send them? That's what I we
I
tell
don't
them.
think so.
Won't either. You know, when I was a young lawyer, Ms. Belcher, I waited for the judges. Now I wait for the lawyers. And it's been going on for years. I'm just telling you. I wonder how those old timers 30 years ago would have handled all this stuff today.
Ready, Judge, whenever you are.
All right, Miss Oro. You're all set now. You stopped and ready to go, right?
Yep, I'm stopped. I was
You
home
guys
all
want the
morning
20
and had to get to work.
I understand. You guys want the 25th?
Yes, Judge.
I don't have a problem with doing it on the 25th. You
Thank
want
you.
another date? That's fine.
The
We'd have to do-
25th works.
Lisa, we can do that in the afternoon. This is likely to go, right?
I believe so, Judge, but I haven't reviewed any discovery. I don't have anything. I don't even have a police report.
Good enough. So we'll set the exam for, you want to do it in the afternoon, Ms. Oro, or what do you want? Because
The afternoon would be better, Judge, yes.
better for you, Ms. Belcher?
Yes, Judge, the afternoon works.
Sir, you have the right to a preliminary exam within 14 days of the date of the within 7 days of the date of the probable cause conference. This is the probable cause conference. Your lawyer needs an adjournment to better prepare. She's asking me to set this for the 25th. Do you waive your right to have the preliminary exam within 7 days of the probable cause conference? Yes or not?
Yes.
Anybody force you to do that?
You don't know. I don't know.
What
Mr.
do you-
Ferguson, it's going to give us time to prepare, sir. You're not waiving the exam, just the timing of the exam. You're out of custody. I do not have any discovery. It's to your benefit.
Okay.
You want to waive that right?
Yes.
Anybody force you to do that?
No.
November 25th, we'll make it. Lisa, am I good at 1 that day?
Yes, 1 o'clock is good.
We'll make it November 25th at 1 PM. Okay? Anything else?
Thank
Ms.
you,
Belcher?
Judge.
No, Your Honor. I believe the people are going to tender discovery to me this afternoon, so then I'll be able to provide it to Mr. Ferguson.
Good enough. Anything else, Ms. Oral?
No, thank you, Judge. Have a good day.
Thank you. Good luck.
You're
We'll see you here in person on that date, sir. Thank you. We're gonna get Mr. Siak in here. Lisa, if you know who Mr. Siak's lawyer is.
Yes, Your Honor, it's John Tucker Davis, and I am here. I was speaking to Mr. Siak.
Okay, we're gonna have to get him in here real quick. Carrie Ruth Moran, 1516W810025, 15W806545.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my clients. Time we consent to the matter being heard via Zoom. As the arraignment, we waive formal reading. My client stands mute.
Wait a minute, let's slow down. Ma'am, your name?
Gary Moran.
Where does she live, Mr. Shemke?
She is currently residing in an apartment in the city of Brownstown with her son. She has partial paralysis, Your Honor. She's been in a nursing home since 2017, recently released this year after getting off a ventilator.
I don't understand. Can you just repeat what you said, though? She's on a ventilator now?
No, Judge, she's been on a ventilator since 2017. She was actually residing in a nursing home in Detroit. She recently, this year, got off the ventilator. She has partial paralysis. She now resides with her 33-year-old son in the city of Brownstown.
So these cases are from 2015. I don't understand. I don't even know what I want to do. I don't think I want to handle this by Zoom.
Can I
Answer the-
tell you, Your Honor?
Well, I mean, I don't know what you want to tell me, ma'am. I want to be understanding, but you haven't been here in 10 years. And I
Well,
guess,
I just wanted to let you know, back in 2015, my husband committed suicide. I had 2 kids in Trenton High School, and I was living on Boxford in my parents' home because I took care of them. And we lost the home. We lost everything after he died. And my body just, it got I got an intestinal infection, went into septic shock, which caused me to go on the ventilator. And
how long were you on the ventilator?
I'm sorry, Judge, what was that?
How long were you on the ventilator?
Since 2000, I would say 16, close to 17.
You've been on a ventilator for 9 years, 8 years?
Yes, I have. Going through therapy and learning how to eat again.
All right, let's slow down. Give me your current address.
23220 Lorraine Boulevard, Brownstown Township.
I'm gonna need some medical documentation. Okay? I'm gonna need some medical documentation to support all this. Right now, I'm gonna give you a personal bond on the retail fraud, but I'm having a hard time with this. I'm having a hard time with this. Unless you never left the house for 11, 10 years, you're really having a hard time with this. I gave you breaks on this and you haven't been here, and I'll give you
I've
a
had a
personal
hard
bond.
time with it too.
Hang on. Let me finish. I don't want to be interrupted. I'll indicate you stand mute, waive reading. And on the retail fraud, you're not to enter or go near any Meyer. Do you have a
Yep, for conditions?
No, you don't want to get one right here. You're not to enter or go near 22600 Allen Road in Woodhaven or any other Myers store. No contact with prosecution witnesses. No contact with employees of the Woodhaven Meyer. Well, this is just no contact with prosecution witnesses. And we'll go from there. I mean, I'm sympathetic, but well, you just can't do this. That's what I'll do. I'll give you a personal bond on the retail fraud. I'll give you a personal bond on the non-payment case that I've given you chances on. Give me 1 second here. Yeah, that's what we'll do. So, I mean, at some point, somebody could have called for you. I'll give you a
They
personal
were
bond
busy
on that,
taking care of me.
I know. Well, they needed to still spend 2 minutes to call us and let us know what in the world was going on. I'll give you a new court date on both of these. These are Woodhaven.
It's on the front.
Oh, I'm sorry. November the 12th at 9:45 on both of these, okay? I don't mind if you appear by Zoom, but I need to. But I still need to have some medical documentation to support this, okay? Good luck. Lisa, give her a lawyer. I'm satisfied she's entitled to a court appointed. Thank you. Is Mr. Siak in here?
Mr. Siak logged in, and can explain that. He's in the parking lot on Zoom. He will come in if the court wants him to come in.
Yeah, but
We'll try to get him in and he refused to come back in.
Tell Mr. Siak to come in here. If he's not in here in 5 minutes, I'm gonna issue a warrant for his arrest.
I
He's
will do
on
that.
Zoom, Judge. I just brought him in.
Siak, Clark, Andrew Steven Siak, 25T7174451. Your name?
Andrew Stevens.
Is Tucker Davis your name?
Don
I'm
Tucker,
sorry, what was that?
P59229, Your Honor.
Nora Hulk on behalf of the people. There is nothing written on that file. The reason is because while we were sitting on there right before this hearing, the victim was here. Andrew Siak and the victim did have contact. The victim advocate here from our office, as did Will, the court officer. I spoke.
Mr. Siak, let's stop. I'm not gonna play.
I'm sorry.
I'm not gonna play games with you. Either
Okay.
walk in here right now or I'm gonna issue a warrant for your arrest and it's gonna be a really high bond. You got about
Why
3
is
minutes.
it like this?
Mr. Siak,
I didn't do the crime. She just told you guys are gonna arrest me and hold me in jail for a
knock it
crime
off.
that I.
Knock it off.
Mr. Siak, I'm advising you to be quiet and
He's
let me-
got 3 minutes to get into this courtroom or I'm issuing a warrant. I'm not gonna play games with you hanging out in the parking lot.
Yeah, you guys are gonna crook me. All right, I'm on the way in.
You got, watch
You
your
got-
mouth.
yeah.
You come in
I'm
there
on my
with a
way in.
different attitude or you're gonna end up in the back one way or the other. I promise you.
Is
Knock
it gonna
it
be
off.
one way or other?
Mute
I'm on
him.
my way in. I just.
Shoot him.
I'm on my way.
Joshua John, Mr. Siak. Joshua John Muniz, 14B108400A and B. I'll take testimony. Where's Mr. Muniz? Your name? Name?
Joshua Munoz.
Where are you at?
I am at work and I am awaiting your courtroom.
Where's work?
Right now, I'm around a block from my house. I'm in Farwell.
Sir, you haven't been here in 11 years. Where's work? Where's your house?
My house is 8590 Finley Lake Avenue, Farwell, Michigan, 48622.
Well, you're going to have to drive down here. Okay? You've been playing with me for 11 years. You want to play games? Go to Sportway or go to a carnival.
Understood,
Set him
sir.
a court date, Lisa. He's driving down here. I'm tired of this nonsense, not showing up here in 11 years. What have you been doing? Fighting in a war somewhere?
No, I've been fighting for my life, actually, sir. I've got necrotizing fasciitis. I've got rare Cinder-Bacter Baumannii. I've had a partial left foot amputation. I've had a lot of problems once I found out that I was diabetic type 1.5. Been out of the hospital.
I'll tell you what, I'm gonna give you a court date. We're gonna say that I'm gonna let you appear by Zoom. And you are going to send us proof of all that, okay? I'll do that for you. We're gonna set arraignment pretrial on both of these, and you provide proof of medical documentation. How long will it take you to do that?
I'm not sure. I can call my primary care and see what documents I can get from them to show you that everything I've said is true.
And Your Honor, just for the purpose of the record, Christopher Shemke appearing on behalf of my client, we did review his constitutional rights, and the statement that he gave to you was also what he said to me.
Why do I have this tether going?
That's why I was on Zoom.
Settle down. Settle down. Mr. Seaton, you are going to have to settle down. I've had tethers in here. They don't always go off. I don't know why yours is going off.
Yes, we said. Okay.
I'm just setting these for November 20th at 9 a.m. I'm not going to arraign them now. I'm not setting a bond. I'm going to let them appear by Zoom.
I appreciate that, Your Honor.
Who's your tether company? You mean to tell me that's on you all the time, going crazy like that? Even
No, it's going great. I was trying to call my Tether officer to get it adjusted. He's busy, and then I was trying to deal with this. So I logged into Zoom.
all right. November 20th at 9 o'clock. That's when I'll set it. Lisa, he can appear by Zoom, but he's going to have to provide us with medical documentation before then. This idea, this notion of people not showing up for 11 years and then getting to show up, whether they're a mile away or 200 miles away by Zoom, is just not going to sit with me very well. All right? Okay. Anything else right now, Mr. Shemke?
No, nothing else, Your Honor.
So you get your medical documentation. When did that? All right, let's go with Andrew Stephen Siak. 25T717-445 Glen.
May it please this honorable court, Don Tucker Davis, P59229, representing Mr. Andrew Stephen Siak, who's present.
I would take it down about 11 decibels if I were. Mr. Siak? Mr. Siak? Humility goes a ways. Arrogance will never help you in here. Acting like you are a superstar will never help you in here. Call over to probation, see if they can come in here and figure out what Tether company they can call, John. I can't have this thing going on if I can't concentrate.
I mean, it'd be great to have it off.
Stop. Mr. Seal.
On the same note.
I wouldn't either if I was you. I just got done telling you that. All right, Ms. Tucker, they're telling me the prosecutor is here. On October 28th, it says he was here on Zoom, and it says 10 minutes.
We're gonna look at him.
But then left at 8:45, which is why I made him appear in person.
Okay.
Now, what are we doing on this case besides addressing a potential bond violation? Anything?
We adjourn this for discovery, which I think is very important to this case to today. We still have not heard or received that. Madam Prosecutor was looking into that. So we do have a preliminary exam date set for November 25th, Your Honor.
We're told the exam is the 25th. They're my test to get all the discovery that.
They're coming in here.
No, Pam said they gotta try to find the anyway. It's gonna be a minute.
You go out in the hallway. Ms. Tucker, I'm gonna need you to zoom back in. They want, it sounds like there's a violation of the no contact provision, at least allegedly. So I'm gonna have to, what's that?
Do you want me to come in person? I could have done that an hour ago. And do you want me to come down there in person or?
Where are you right now? Are you in Trenton?
I'm in Detroit. I can get it right on I-75.
I mean, if you want to, it's not, yeah, maybe you should. Maybe you should. We'll get his Tether dealt with because I feel like I'm at a carnival right now. Get here when you can, please.
Is it possible to address my attorney?
Not now.
I will leave right now.
Okay, thank you very much. We'll see you back here. Thank you.
Can I log into Zoom there? You guys wanna do it? You said see all.
You're gonna, listen. Why don't you go out in the hall? Why don't you go outside?
I'm tired of all. All right, this question?
Come on back up here. I don't need you even in the hallway with that buzzer going on.
That's the process. Sorry, sir.
Well, let me finish. Well,
Okay.
when I call your case, you're coming.
Thank you.
Okay, and if they figure out what is going on with this Tether, and they will come out and you guys will work with the Tether company and shut the thing off, so I don't have to listen to that. Nobody else does. Is that
For the police that we just called her here because she came and caused a problem at my location and I
Yeah.
called police first.
Yeah. I told you once before. Come on back up here. Don't walk away from me.
Oh, I'm sorry, okay, who's looking outside?
I told you once before I'd take it down about 11 notches. Now I'd go 732 and a half notches down. If you come in here with this attitude, son, you're not helping me with that.
I realize that, but I feel like you guys just railed it.
I railed it.
Not you, but like,
Nobody's,
Six-
nobody's railing me, buddy. Knock it off. Stop. Go cry in your tears if you want.
I don't cry, I'm just.
I don't really want to hear your nonsensical gibberish. You got what I'm saying?
Yes, sir.
Quit acting like a tough guy. We'll have the hearing when your lawyer gets here. I'm gonna be fair with you. I'm not listening to you.
That's all I was worried about.
We have no reason to worry about that, Mr. Siak.
Yeah, you're a good judge.
Go out to your car.
Sir.
Oh, I didn't think. Do we have anything else? I'm gonna call Siak. Andrew Steven Siak, 25T7174451.
Really well.
All right. Good morning again, Ms. Tucker Davis. Your name?
May it please the sign of the court, John Tucker Davis, P59, representing Mr. Andrew Siak, who stands to my right. Could you introduce yourself, please?
Andrew Stevens, hi.
All right. So we have today scheduled a preliminary exam.
We have it scheduled for an adjourned PCC today for the discovery. We have the preliminary exam scheduled on November 25th, Your Honor.
Oh, you're right. You're right.
Today was the day for discovery.
Okay. Do you want to take up your issue with regard to violation of the no contact?
Yes, Your Honor.
Or do you want me to just reiterate?
I'd like to at least state it on the record so you're aware.
Go ahead.
So the complainant, Shelley Zajic, was here today. I spoke to her after she walked out of the conference room that I was sitting in. I was informed that she and Andrew were talking outside. The court officer, Mr. Will, observed this, and so did my victim advocate. He also said something to my victim advocate saying, and she's here to testify to that as well, that the victim no longer wants a no assaulted. So I brought the victim back into the conference room. I asked her what happened. She told me that Andrew was telling her to change the no contact to a no assaulted contact. And given that he's talking to her here at the court today, and trying to tell her to change the contact order, I believe that's a huge no contact violation. I'm really concerned for the safety of this victim, the severity of her injuries at the time of this incident, and the history that they have. That is a big.
All right. You want to come forward, ma'am?
Victim advocate.
Where's Ms. Zajic at?
So there was a miscommunication between the advocate and I, and a cab was called for her. It was already called. And so when she ended up leaving, they tried to go get her, but she's not able to make it back.
Mr. Sia?
Sir?
Stop acting melodramatic. Mr. Sia?
I don't understand what I did.
Mr. Sia? Can she get on Zoom?
She doesn't have a phone.
How was there this lack of communication? This is pretty serious.
Today was the first time I was able to speak to her because apparently she didn't have a phone all this time. And there was an incident this morning as well. She was able to get here today because the police were called to, I believe his residence. They were both there. There was arguing and screaming, and the police were called. They were both picked up and they were brought here. That was the way that I was able to speak to her.
Mr. Siak. Stop. Did she lie to me just now?
Yes.
Okay.
No.
Okay.
It was the same.
Stop. Wait a minute. I want to make sure I understand what you just said. You just told me that the police were called over there. There was some kind of a disturbance where Ms. Zajic and Mr. Siak were, and that's how they got to court?
Yes.
That is incorrect.
Mr. Siak?
The chief of police for Grosseal was here. He was the one that informed me.
Let's get people here. I want to hear this testimony. Mr. Siak, please. Are you under the influence of something right now?
I am not. just this is all incorrect. And this is why I feel like, I'm being, treated in.
Nobody's treated anybody,
Say it true.
Mr. Siak.
know what I'm saying?
You want to get the Roseville Deputy Chief here?
I do.
He made mention of me as well.
I do. I'd like you to get him here.
Oh.
Mr. Siak.
As frustrated as you were this morning over at Tether, and I think I was kind of anxious. We were speaking about that, and so it just needs time to settle down.
He walked in here anxious with the tether going at 8:30 or 45 whenever I got out here. Mr. Siak,
Yes, sir.
you want to let your lawyer talk for you.
They didn't say a word.
Mr. Siak,
Sure, sir.
settle down. I'm going to get to the bottom of this.
Thank you.
Should we sit and wait?
You should sit and wait for the deputy chief, and you guys should try to get the victim back here. I can't believe in this day and age she doesn't have a phone or a text or no computer that anybody could text her.
What happened, and I don't want to state anything. I don't know if it was broken or if she lost it. I don't remember, but I know that she doesn't have a phone right now.
Well, these are serious allegations that you're mentioning here. And if they are true, there's only one or two things probably that are true. And that is either they're truthful allegations or they're false. And either way, somebody's going to have a big problem with me when I get to the bottom of this. But Ms. Zajic shouldn't have left until the case was called. The deputy chief, we're going to get over here and he can testify. And Mr. Siak's going to calm down.
This is what I was hoping for, Your Honor.
Mr. Siak,
Yes, sir.
please stop interrupting me. I don't want to be interrupted.
I apologize, sir.
So we'll get the deputy chief over here. If there's any other people you can get over here. If she wants to come back, I'm willing to continue this in the afternoon. This scares me. You said something about the injury she sustained.
From this incident, yes.
Right.
This was back in June 22nd, just based on the report, officer observed injuries and found some concern.
I got it. Okay. Let's wait until we hear from the deputy chief. Do I have anything else ready out there right now? And then I'll call that. Please, people against Andrew Stephen Siak, 25T7174451. Come on up here, Mr. Siak, with your lawyer. Counsel, your appearance, please, Ms. Tucker Davis.
Good morning, or good afternoon, Your Honor. Nora Holier on behalf of the people.
And John Tucker Davis, P59229.
By the way, it's good to have you here. I knew Ms. Tucker Davis when I was about 10, right? Your name?
Andrew Stephen Siak.
All right. Now, so we have the deputy chief here?
Yes, sir.
Sir, what's your name, please?
Deputy Chief Rozak, Roseville Police Department.
So do you want to talk to him? Are you satisfied you can go forward now?
I can go on.
Okay. You want me, I'm going to swear him in then. Okay. And the issue here is whether or not there was a bond violation. So you guys can have a seat, relax. Deputy, why don't you come on right up here to the witness chair, please? Raise your right hand. Somebody swear to affirm under penalties of perjury the testimony you'll give in these proceedings be the whole true self you got. All right, have a seat, please. Go ahead, Ms. Allen.
Can you please state your name for the record?
Deputy Chief Rozak, Todd Rozak, Roseville Police Department.
Could you spell it out for the court reporter, please?
TODD, last name Brozak, B as in boy, RO, Z as in zebra, K King.
Mr. Brosick, did you come here to the court today?
I did.
And today is November 4th, 2025.
Correct.
And when you came here, you informed me of an incident that occurred with Andrew Siak and complainant Shelley Zajic, is that correct?
Correct.
And could you tell me what you know about that incident that occurred?
I was here on the state docket, and my road officer had called me directly and said that he was at the residence and there was an incident And your subject, your defendant, Mr. Sierra, is said that he needed to be here at court at a certain time. And if I could relay to the court officer that he was going to be delayed.
And so to your knowledge, was Shelley's agent at the residence this morning, at Andrew Siak's residence?
Your Honor, I would object and ask for clarification. Were you actually at the residence?
No,
So, yeah, you could, I can ask there, were you actually at the residence?
it's not.
And it was your road officer that was at the residence.
Correct.
And he informed you that, he was at Andrew Siak's residence and Shelley's agent was there?
Yes.
Do you know any other details about that incident?
Nothing that I was not there. So there is a report that's being generated.
Were there any arrests?
No.
And was anybody reported here by a road officer?
Yes, your victim.
The Shelley's agent was transported? And if you know, was Andrew Siak transported? Did he get here on his own?
I do not know how he arrived here at Toy.
I am familiar about that.
Any evidence that she was there against her will?
No.
Any questions of them? You,
No, Your Honor, thank you.
you can step down. Thank you. What do you want to say? Anything?
Just that, Your Honor, there is a no contact order in this case. The report was generated. They were both at the residence at that time. In addition to that, what happened today at court, they were making contact. I also asked a victim advocate here that observed that, as well as a court officer that was out the front. And I was informed by the victim herself that Andrew Siak had told her, to.
What in the world was she doing over there if this you can step down, sir. What in the world was she doing over there at his house?
Your
Do we have any evidence as to why she was there?
The reason that she told me was that she was going there to pick up her keys. Keys, I believe, to a vehicle, if I recall correctly.
All right, I'm gonna cut this short. Jack, I want you to understand something.
Yes, sir.
You don't have to sir me, and you don't have to say anything right now, okay? When you have any contact with her, regardless of who initiates it, that's a violation of the no contact. If she comes over to your house and you let her in, that's a violation of no contact provision, not by her, by you. I didn't order a victim not to have contact with you. I ordered you not to have contact with the victim. If she calls you and you pick up the phone, that's a violation of no contact. She comes to your house, you let her in. That's a violation of no contact. She emails you and you email back. That's a violation of the no contact provision. She texts you and you text back. That's a violation of the no contact provision. So stop acting holier than now. I can't stand that.
Well,
Mr. Siak. Don't shake your head at me, son. Do not shake your head at me.
Yes.
You understand what I just told you?
Yes. I didn't realize I can't say something I'm not.
Let you talk. Hang on.
Yes, sir.
I can caution. I can tell you that if I were you, the last thing I would do is talk right now. That's just me. That's just me. You want to talk? Feel free to talk. I got all day to listen. John, go warm my coffee. You can talk for 4 hours if you want. Because you cannot sit and listen, son. You're gonna interrupt. You think whatever. Go ahead, talk. Say what you want to say. Might get you in more trouble.
Speaking with my attorney.
No, you sounded like you wanted to address the court. You looked at me when you said I want to talk. You started to interrupt me. You want to talk? I got all day. It's 12:20. I won't take a lunch. We can sit here till 4:30 if you want. I got a wedding at 4. But I can listen to you for 3 hours and 40 minutes if you want.
I think Mr. Sion is going to allow me to speak for him.
Okay. Jeez. It's the smartest thing I've seen him do all day. Go ahead.
Your Honor, from the testimony, if we do have a witness if necessary, but if from the testimony, it appears that the complainant came to the house. There is no evidence that Mr. Siak let her in or engaged in any conversation with her to come there. We're asking for this violation of no contact.
You're still under oath. Was the information conveyed to you that she was in the residence? If you don't know, you don't know.
I know she was present. I don't know if she was inside of home.
As I was starting to say, those are violations of the no contact provision when she contacts you and you have anything to do with it. Okay?
Yes, sir.
If I was you and I saw her approaching in my house or my yard, my property at all, I would lock the door, shut the drapes, and call the police and say, the victim is here and I don't want to be accused of violating any no contact provision. You don't need to interrupt me. That's what I'd do.
Yes, sir.
Didn't nobody. You just want to interrupt. If I had a nickel for every time you've interrupted me today, I'd have enough to buy a whatever. I'm telling you, Mr. Siak, you better change your attitude. There's not enough here for me to violate him under these circumstances. Plus, next time you need the witnesses. You need her and you need the responding officer, not the deputy chief who's told something by the responding officer. We're going on November 24th on this, right? 25th, I'm sorry. November 25th, exam to remain for November 25th, hearing held regarding violation no contact. I want to be clear. If she's there and you let her in, that's a violation of no contact. Do we understand one another?
Yes.
I'll just make a note. Defendant found not guilty of the bond violation. We'll see everybody here on the 25th.
Your Honor, if I may make a record.
Yeah.
We were here today under the Joint PCC for outstanding discovery. In the paper police report and that I did obtain, there was a second person in the room while the complainant was making a statement. We are requesting to find out if that person made a statement to the police. There are outstanding photographs of any alleged injuries in this case that we were asking for. There is also a written.
Did I sign a discovery order in this case?
I don't recall, but Your Honor, I already informed defense. I requested it from our OIC. I spoke to another detective here today from Trenton, and he's going to make sure that all gets in.
Okay, make sure you get a tour in the next few days, though.
No, I
Because
understand.
there's no way I'm adjourning this. What else do you want?
And the exam is the 25th.
I know. You're gonna get a tour by hopefully this Friday at latest, right?
Of course, I always do my best.
I know you
I
do.
do want to say that Madam Prosecutor has been very cooperative in this. She's been trying to obtain it, but I needed to make a record.
Sure.
Thank you.
I got it. Anything else?
No, Your Honor, nice
Nice to see you. Nice to see everybody. We will see you here on the 25th. Thank you very much.
We will go on the record in the matters 24 CF 247, 24 TR 1118, 25 CM 201, 25 FO 248. State of Wisconsin, County of Burnett versus Josie Taylor. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Taylor in person. We have appearing by video conferencing capability, her counsel, Zachary Fisher. We also have the victim's attorney, Christina Kerr, appearing by video observing this hearing. We're set today for status conferences and an initial appearance in 25 CM 201 and 25 FO 248. Mr. Fisher, were you able to go over the criminal complaint in the new matter with Ms. Taylor?
Yes, Your Honor. She has received a copy of the complaint. She's aware of the maximum penalties and the allegations. We would waive any further reading. We're not requesting a speedy trial at this time. We would guilty on the misdemeanor and the forfeiture matter. And
Yeah,
I would
you
ask to
are,
track these along with.
Mr. Fisher, you're in bad. Mr. Fisher, stop talking. You're cutting out a lot.
Oh, I apologize, Your Honor.
Yeah, it's very hard to hear. It's like every other word.
My apologies. Let me see if, is this any better?
Maybe? I'm not sure, but I guess talk and we'll see.
We have received a copy of the complaint. We would waive any further reading, enter not guilty pleas on the misdemeanor as well as the forfeiture matter, waive speedy trial, and ask to track them along with the felony matter.
All right, not guilty pleas will be entered on her behalf on those matters. You are entitled to a jury trial for the misdemeanor, and you would be entitled to a speedy trial with that matter. With the other matter, you are not. It is an underage drinking first offense, 17 to 20 years old. What is happening in the other cases, Mr. Fisher?
Your Honor, so I have talked with Attorney Schmidt on this one, and I do again want to apologize for the misunderstanding that came from my end on this. I was under the impression and hope that Ms. Taylor's insurance that is partially covering her civil matter would be covering either part of or in full some of the restitution in this case, and that I frankly should have looked into this more thoroughly before we were proceeding, as I am obviously not a insurance attorney or a civil attorney, so I was not very familiar with whether or not the company would cover those damages. But upon discussing, I have reached out to the insurance agent representative, and it's my understanding that they do not cover criminal restitution as it pertains to this case. So I have had discussions with Attorney Schmidt on how we would proceed, and I believe we do have an agreement that we wanted to present to the court today, where Ms. Taylor would stipulate to the restitution as requested, and she would pay an upfront amount between $2,000 and $4,000. We're currently trying to work on and see how much Ms. Taylor can come up with. And then in exchange, Ms. Taylor would enter a plea to OWI second without the injury enhancer and would be placed on probation for a period of 1 year with state conditional jail, as well as conditional jail up front for the mandatory minimum offense. And probation would allow the court to, whether it be through restitution court or just as a condition of probation, enforce and provide Ms. Taylor an avenue to make those restitution payments without it just being sent to collections. So that's what we were hoping to do and set for the next hearing going forward.
All right, and Mr. Schmidt's aware of this, but I'm not sure if you're aware of this with that new 25 FO 248, the underage drinking. There's very little that can be done in that matter because the legislature is very strict as it relates to underage drinking. So that's not one that can be DRI'd.
Yes, Your Honor.
What does DRI mean?
Dismissed but read in.
Oh,
So it's not
okay.
one that can be part of the everything else goes away.
Yeah.
But that is something where there would be, and I'll tell you right now, with an underage drinking 17 to 20 as a first, it would mean a forfeiture of $263.50. So a fine of that amount. Suspending your driver's license for 60 days or attend an alcohol awareness class. You would need to do that anyway if you accept the offer with that other plea. Okay, so that's something that you would be able to do dually with this and with that other charge. So that's all with that underage drinking. You would just need to do that class.
And when do I have to complete that?
You would have 60 days to complete that from the time of pleading. Okay.
And the new charges are going to be on my next court date or today?
Well, everything's going together.
Okay.
So everything will flow together. Okay. So talk to your attorney about that one, about all of it together. And so what are we doing then, Mr. Fisher? Are you asking to have it set for a plea and sentencing?
Yes, Your Honor, I would ask for that if that's okay with the court.
And we are in victims' rights compliance. We are? Okay. And are you asking for any amount of time to be able to gather that $2,000 to $4,000 to prepay?
No, I
Your
have
Honor.
majority of it.
Excellent. Well, she answered it, so I'm
There you go.
pretty, I could do it as early as November 17th, or I could do November 18th.
What time would the court, let me check the 18th, it's probably better. I have time in the afternoon on the 18th.
Okay. Let me just take a look on the 18th, the afternoon. Oh, yep, I'm booked on the afternoon, but I could do the 17th afternoon.
Let's see if I can. I don't think that would work for me, unfortunately.
I could do December 11th, anytime in the morning.
I don't think that'd work because I think I need to be able to do this. And I'm
Oh,
at
sorry,
Scott.
I hopped weeks and I thought I was on your week. I could do December 18th. I could do it at, no, I can't do the December 18th. I could do, wowza.
And I apologize to interrupt. I guess I would leave it to the discretion of the court and to Ms. Taylor if they would like me to be there in person, given the relative complexity of this case. Okay, then yeah, I would another date then.
I could do January 26th at 1:15.
Do you have time later in the afternoon that day?
I could do 2 o'clock.
That would work for me.
All right, 2 o'clock on January 26th. It's only set for a half an hour though, or Ms. Bauer, are we going to have statements? And if so, are they going to be lengthy?
I don't know about lengthy, but I'm pretty positive we have a victim statement.
Or I could do the 29th, January 29th, anytime. You have your pick of times except for 10.
Anytime works for me that day. So whatever works for the court or Ms. Taylor or the victim.
Let's do it right off the bat at 1 in the afternoon. Right, set it for an hour, please. So 1 o'clock, January 29th. Anything further, Mr. Fisher?
I do
No,
have
Your
a
Honor.
question.
Yes.
For them new cases, am I able to do that alcohol awareness right away?
Yes.
Okay.
You can, but make sure though, it has to be an OWI assessment.
Okay.
Okay, because if you just say AODA assessment, it's not gonna, you have to say AODA OWI or something like that, okay?
Okay.
So you can go to Aurora to do that. Or I think the St. Croix tribe still does that.
I still have the same provider from the first ones.
Okay, excellent. So you can do that and you have to prepay with that. And I'm going to give you a little bit of a warning here. I know you're going to have a lot of restitution and it's going to, everything goes towards restitution first, but with the underage, that $263.50 has to be paid separately because otherwise if you don't pay it, it kind of tracks along with your driver's license and that. So that's when that has to be done separately.
Should I do that right away?
You sure can.
Okay.
And you can go talk to Amy, the clerk out there, to see about what to do with that, how to prepay that or whatnot. Okay? Because otherwise you have a lot of restitution to pay back and that'll just hang out there forever and ever.
Okay.
Okay, so if you do it first right now, then that'll be taken care of.
Okay.
Okay? Any other questions, any other things, Mr. Fisher and or Mr. Schmidt?
Not for me.
No, Your Honor, thank you.
Anything else, Ms. Taylor? All right, come get your notice, and then if you want to stop and talk to Amy before you leave. Thank you. We are adjourned. We will go on the record in the matter 24 CF 155 State of Wisconsin versus Glenn Wood. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Wood in person with his counsel, Daniel Furcus. We're set today in this matter for a plea and sentencing. The 24 TR 688. We're set for a plea and sentencing in this case. Mr. Furcus, can you please recite the agreement that's been reached?
Your Honor, my client would be pleading guilty to count number 2 of operating a motor vehicle while under the influence. The third count would be dismissed or merged and dismissed. And I believe count 1 would be dismissed and read in. There'd be a joint recommendation for an IDIP guideline sentence.
Alrighty. And it's my understanding he has not sat 48 consecutive hours. Is that correct?
It was not consecutive hours. His time did cover 2 separate days. However, they were not 48 hours.
Okay. All right. And so I need to make sure that you understand, Mr. Wood, because I like to make sure that the defendants understand everything, that the law requires OWI thirds and higher to sit 48 consecutive hours. That means hour after hour for 48 hours before the court can grant any release on electronic monitor for house arrest or anything like that. And so do you understand that?
Yes, I do.
And it would be a immediate report. So after we're done here, you would immediately go to the jail, report, and sit 48 consecutive hours. And then if the court grants you the monitor, then you would be hooked up on that. Do you understand that?
Yes, I understand.
And do you wish to proceed with this plea and sentencing?
Yes, I do.
Okay. All right. So, Mr. Wood, I have in front of me this plea questionnaire waiver of rights form. Do you recognize this document?
Yes, I do.
Did your attorney go over this document with you thoroughly?
Yes.
And did he essentially go over it word for word?
Yep.
And so you understand everything correctly?
Yeah.
And did you sign that document?
Yes.
And there's an addendum to that plea questionnaire and waiver of rights. Did he go over that document with you?
Yes, ma'am.
And you understand it completely?
Yep.
And then is that your signature?
Yes, ma'am.
Okay. So it says that you're 65 years old. You have 14 years of schooling. You can read, write, you understand the English language. Is that correct?
Yes, ma'am.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Absolutely.
Did your attorney go over with you the mandatory minimums as well as the maximum possible penalties that you face?
Yes.
You are receiving treatment for mental illness or disorder, and you have had medications. Either of those interfere with your ability to comprehend or understand what's going on?
No.
And did you take your medications as prescribed?
Yes.
And so are you in a state right now where you fully understand and you can comprehend everything that is happening?
Oh, yeah.
Okay. Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page of the plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, ma'am.
And you understand them completely?
Yep.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yeah.
Do you understand that here the state would have to prove for count 2, operating a motor vehicle while under the influence, a third offense, that on or around July 4th, 2024, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of a controlled substance? Do you understand what the state would have to prove?
Yes.
Do you understand that they would also show that this would be your third countable offense?
Yep.
Do you understand that upon conviction, you could be fined not less than $600 nor more than $2,000 and imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, ma'am.
You also understand that upon conviction, the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA OWI assessment and follow through.
Yes, ma'am.
Now, do you also understand that with regards to this case, there is an agreement because you've completed the IDIP program, but do you understand that the recommendation calls for the court to follow those guidelines. But the law states that if I think in my discretion, based upon facts and the circumstances, that a more harsher, stricter sentence should be applied. Do you understand? It's my discretion and I can do that.
Yep.
Do you understand? I could sentence you all the way to that maximum possible penalty if I thought it was warranted.
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
I sure do.
Did you go over that criminal complaint with your attorney?
Yes.
In particular, that section where it's called the probable cause section, and it basically says what happened that day and why you were charged with these crimes?
Yes.
For the most part, are those facts accurate?
Absolutely.
Are you admitting here today that you in fact did operate a motor vehicle while under the influence of a controlled substance?
Yes, I am.
And this would be your third countable offense.
Yes, I am.
Mr. Firkus, may the court use the probable cause section of the criminal complaint to find a factual basis?
It's adequate, Your Honor.
Has anyone made any threats or any promises to you, Mr. Wood, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Absolutely.
and voluntarily?
Yep.
Has your attorney represented you competently?
Yes, he has.
Has he answered all of your questions?
Yes, he has.
Has he looked at this matter thoroughly?
Yes, he has.
And are you satisfied with his services?
Very much.
Do you have any questions for the court or for your attorney before I proceed?
No, I don't.
As to count 2, operating a motor vehicle while under the influence, third offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. The other counts in that case in the TR matter will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. We have the intoxicated driver intervention program to address and incentivize people to get treatment prior to entering pleas and to take steps that will be necessary to get their licenses after the conviction. So there's a good public interest for it. In this case, the defendant did that. They should have the reward for doing that. This is an RCS OWI. There was no alcohol and it was a low amount of THC. THC has lesser of an impact on driving than alcohol, so I think this should be followed. Thank you.
Thank you. Mr. Firkus.
Your Honor, we'd ask that you go along with what is a joint recommendation. I know you have to look at the seriousness of what occurred. It's OWI. Legislature's already told us how serious they take that by having mandatory minimums and things like that. I know you have to look at my client's character. His prior offense was from 2006, conviction of 2007. Pretty long gap between these. I know this happened in July of 2024, so we're a year and 4 months that he's been on bond, felony bond, no issue, no problems. He's completed all requirements of the IDAP program. I will not go into the details of that, Your Honor, as you are familiar with the program in your own county. And finally, you have to look at protecting the public. The sentence protects the public. It has consequences in addition to the immediate consequence of spending time in jail. He's going back to the jail today. And then to get his license back, he's had to do the assessment. He will have to have an ignition interlock device. All these things are kind of built into the sentence for protecting the public, Your Honor. Thank you.
Thank you. Mr. Wood, do you care to make any statement today? Let me know anything. You
Well,
don't have to.
I just want to say that I'm not thankful for what happened, but I'm thankful for the program and the counselors that helped me through this. I mean, I got a lot of medical issues and I thought I needed weed to suppress it because they wanted to put me on fentanyl patches and all kinds of other stuff for my illness. And I told them that marijuana was doing it right. And so I had edibles and I've been doing edibles for 8 years. But I've been sober and off drugs for 9 years, a little over 9. And I'm glad that I got to take a look at this again and put me on the right track because I actually feel better right now.
Really glad to hear that.
Medically too. So
It looks like you are. I remember when you first came in here to court, not that you looked bad by any means. And not that you looked grumpy, but you have a different disposition about you here today. And it looks more cheery and uplifting.
Well, I'm just glad I was blessed by probably this thing too, to get back on track and stuff.
I'm sorry to hear about the pain that you suffer every day, having the chronic pain. That's not something that is easy to deal with and to handle. But it sounds like from what you've went through with the program and the counselors, you have a better way of combating that and fighting that, and it's put you in a better disposition.
Exactly, and I got a couple new sponsors out of it as far as I'm concerned.
And that's excellent. And I think this is your wife.
Yeah.
She's here and she's been here, I think, for every hearing with you. And so you have her support, and it's good to see. And I'm looking at her and her face and what she's feeling right now. And it looks like she probably has Glenn back, a better Glenn, because I'm not saying that you, again, were grumpy or anything previously, but you have this lighter feel about you here today.
Thank you.
This is definitely a serious matter. Obviously, it's stated by both parties, and the legislature does tell us with the high penalties and fines and fees, as well as a mandatory minimum with the OWI third and on. So it is serious. You've went through the program. You've learned a lot of things. You have a good character, and you are accepting the responsibility. You are being accountable, and you've learned a lot about yourself. You've done a lot of self-reflection about you personally, about your healing, about your pain, about everything in your life. And that's all positive, and you want to do better. And so that makes me feel better. I don't believe that you're a risk to the community, that you're going to do any harm. I think that this was something that happened. It may have happened for a reason, and the reason is to help and better you.
Absolutely.
And I'm very glad to see that. So there's no reason the court should stray from the IDIP guidelines and the recommendation. So what the court is going to do is, with the restricted controlled substance, $1,286 in fines and fees, plus a $10 blood draw, 45 days in jail, 24 months of revocation of your driver's license and ignition interlock device. Oh, I'm sorry, you're not it. She's not my OWI clerk, so it's a little bit,
Okay.
I need to go slower with her with the OWIs. And that's totally fine. I'm used to, but she's learning. It's all good. So let me know if I need to repeat something. 45 days of jail, 24 months of the ignition interlock device, and revocation of your driver's license. When we're done here today, or once you're released from the 48-hour consecutive hours, you can report and go see Amy, our clerk out there, who's usually clerking these types of cases, and you can get a half-priced ignition interlock device form. Okay, so it's always good to have a half price, and if you have to have it, half price is good, and it's a better insurance that you're going to go ahead and get that done. So it also says 25 hours of community service. I don't know if you've done that extra time. I don't know if you want to do that extra time, but you do have the ability to convert that 25 hours of community service to additional jail days. So it would be 4 additional jail days. So it would cost an extra $100 to be on that monitor if you wish to bypass the community.
I've got 9 hours and
You have how many?
9 so far.
9 so far. And so do you want to, I think that's there's a program requirement of 8. And then
I already did them.
Oh, you did. So you're on your way to getting 25.
Yeah.
Excellent. You just have to have them completed by the end of your sentence. All right. And so if you are going to be on monitor? And again, I see no reason why not to allow you to be on monitor. You're doing well, you're doing good, and you want to continue to do your community service. So I'm going to grant you the ability to be on that electronic monitor. It's house arrest, but it can be for Huber or community service. You can go to work, you can go to community service, you can go to doctor's appointments, you can go to AA, you can go to those types of things. Okay? Because those are all positive things I want you to continue to be a part of. Okay?
Thank you.
You can go to the grocery store one time a week, but you have your wife, so I don't know if that's a dual thing that you do, or if that's a her chore
That's
versus
mine,
your
no.
chore type of thing. If there's something like, let's say, Thanksgiving dinner at the grandkids' house, that's something you won't be able to attend. But if it's something like somebody unexpectedly passes away and you have a funeral, all you need to do is talk to Miss Anderson and write a letter, and I will determine whether or not that's something that's approved or not approved. And again, that would determine the relationship and those types of things, because this is house arrest. You must prepay at 30 days ahead.
I already did.
Excellent. I'm glad to hear that. So everything seems to be good and seems to be in order. You have, I think it's $1,000 cash bond paid, and that goes and pays off most of your fines and fees. With the remaining fines and fees, I will accept a payment plan of $50 a month until paid off in full. Okay?
Okay.
So once you know how much you owe, just make sure you pay $50 a month. Failing to pay, the court would enter a civil judgment against you, or you could get a warrant and sit up to 6 months in jail. We don't want that. If you are having a significant and substantial financial hardship and you can't pay that for some reason, you have to write the court and we'll look at that and I'll review that, okay? 2 days jail credit, but not 48 consecutive hours. So when we're done here, you must go immediately report to jail, sit your 48 consecutive hours, and then Mr. Hatch and or Ms. Anderson will figure out who's going to come and put you on that monitor, okay? So you can be released. I would strongly encourage you stay away from any rubbing alcohol, any gasoline, anything that has alcohol like sanitizer. It could set the machine off. And then if it goes off and it says that you have a positive for alcohol, unfortunately, you're going to be told you're immediately revoked and you must go sit the remaining time in jail. No good time, no Huber. Okay? So very important you stay away from those types of things.
All right.
Don't touch that stuff.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. The jail makes sure that they take that. In a case like this, you may be able to get it expunged through a written letter to the Department of Justice. It's easy to do. You can Google it, or you can ask Mr. Ferguson. He can assist you that way. Am I missing something, Mr. Schmidt?
Not for me.
Mr. Fergus?
Oh, Your Honor.
All right. Good luck, Mr. Wood.
Thank you, Your Honor.
I'm proud of you, and I'm proud of where you are here today.
Thank you.
All right. We will go on the record in the matter 25 CF 132, State of Wisconsin versus Angel Moa. The state appears through District Attorney Kevin Schmidt in person. Mr. Moa appears in person with his counsel, Glenn Keene. We're set today for a status, but the parties have reached an agreement. And are we in victims' rights compliance?
Yes.
All right, so we can proceed with the plea and sentencing. The court has an electronic copy of the plea questionnaire waiver of rights form. Mr. Keene, can you please recite the agreement on the record?
Yes, Your Honor. It would call for Mr. Moore to plead guilty to count 1, take and drive a vehicle without consent, with counts 2 through 4 dismissed and read in. It involves a joint recommendation of a withheld sentence for 2 years of probation with conditions of probation, time from arrest to sentencing as conditional jail. That would be 62 days through yesterday. He owes restitution to the owner of the vehicle, PV, that's his mother, of $847. It also calls for an alcohol or drug assessment and follow through.
All right, thank you. Again, I have one more question before we proceed. The co-defendant in this matter, is that a significant other? Do you have a co-defendant?
Oh, yeah.
Yeah, that's your significant other?
That's my girlfriend.
That's what I was wondering.
Okay.
And so you're going to be a father?
Yes,
Do you have any other children?
that's the first one, Your Honor.
Well, that's exciting. So I always like to know as much as I can before sentencing, so that's why I was asking. So,
Oh,
all right. Well, congratulations.
thank you.
All right, Mr. Schmidt, I don't need to go to you right now, but I guess first, this is in the public interest and we are in victims' rights compliance, correct?
Yes, and it is in the public interest. This effectuates getting his mother paid back. I think the probation is appropriate for this offense. Most of his criminal history is status offenses, OWL 2 within 3, misdemeanor bail jumping. All of his history is in Marathon County except one Shawano conviction. So I'm not trying to create like strong ties to here in Burnett County. I think he was mainly just here because his girlfriend is local. Simone is from Sawyer County. The only relevant convictions he has for these offenses would be a fraudulent credit card use in 2009, a forgery in 2015. And that's it.
Thank you. Okay, Mr. Mua, I have in front of me that plea questionnaire waiver of rights form. Did your attorney go over that document with you thoroughly?
Yes,
Did he essentially go over it word for word?
yes,
And did you understand everything completely?
yes,
If by chance you didn't understand something, did you have him explain it to you until you did?
yes,
And I have the unsigned copy right now, but you did review it and sign a copy today, correct?
correct,
And that has now been filed with the court. You are pleading guilty to one count of felony take and drive a vehicle without consent. You're 35 years old, you have 12 years of schooling, you can read, write, you understand the English language, that's all correct.
correct,
Your attorney, did he go over with you what the state would have to prove your guilt beyond a reasonable doubt?
yes,
Did he go over with you the maximum possible penalties you face?
yes,
No drugs, no alcohol, no mental illnesses or disorders, correct?
correct,
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Your attorney has that document in front of you right now. Did he thoroughly go over those rights with you?
yes,
Do you understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
yes,
No longer able to vote in any election until your civil rights are restored.
yes,
You understand here that the state would have to prove as to count 1, felony take and drive, operating a motor vehicle without owner's consent that on or around September 3rd, 2025, in Burnett County, Wisconsin, you intentionally took and drove a vehicle, a 2009 Nissan Murano, without the consent of the owner, PV. Do you understand what the state would need to prove?
yes,
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
yes,
Do you understand that there is a recommendation here to the court for what's called probation with a withheld sentence? Do you understand what that means?
yes,
Do you understand what an imposed but stayed sentence is?
yes,
Do you need me to go over the difference in any detail?
no,
Do you understand that I'm not bound to follow any recommendation by either side?
yes,
Said differently, I could sentence you up to that maximum penalty, or I can do any array of sentencing decisions if I thought it is warranted. Do you understand that?
I understand,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over that criminal complaint with your attorney?
yes,
In particular, there's that section called the probable cause section, and it basically says what happened that day and why you were charged with the crimes. Do you remember that?
yes,
For the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did take and operate a motor vehicle without that owner's consent?
yes,
And you knew you did not have that consent?
yes,
Mr. Keen, may the court use a probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Has your attorney represented you competently? Has he done a good job?
oh, yes,
Has he looked at the matter thoroughly?
yes,
Has he looked at the discovery, the evidence here and discussed it with you?
yes,
Has he looked to see if you have any defenses or a lack of defenses in this case?
yes,
Are you satisfied with his services?
yes,
Any questions for the court or for your attorney before I proceed?
no,
Then as to count 1, operating a motor vehicle without owner's consent, how do you wish to plead?
guilty,
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept that plea of guilt. Based on that, I will find you guilty of count 1. Counts 2, 3, and 4 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I think we need the probation, one, to ensure the restitution gets paid back. And also, you have to wonder if substance abuse issues are connected to the history, because he does have the prior methamphetamine conviction with the repeater. He's got the 2 prior kind of similar credit card offense and the forgery, which are similar to the taking of the card from his mother in this case. And his girlfriend has a significant history of substance abuse in Sawyer County. So I really think that the probation is going to be necessary, not just to address issues with taking things, but addressing underlying substance abuse issues. So I think that's really why I have it there and why I have it for 2 years. Like I said before, most of his convictions are for OWL 2 within 3 or bail jump, but he has so many convictions for that's why the 2-year probation is asked for it. Like if I had to count this, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. This will be his 25th criminal conviction. Like I think he's got like 12 convictions, 12 to 15 convictions for OWL and bail jumping. Thank you.
Thank you. Mr. Keen.
Yes, Your Honor. Mr. Moa acknowledges the gravity of the offenses and it's weird because at first it's, a less serious crime because you don't have the force or other things, but as you know, before and on the record, it's a little bit more serious because it has the, harm to the family relationship because it was his mother's vehicle. She, called to try and get back and he, did not return to her. And the joint recommendation does allow for substance abuse needs that Mr. Moa has and have monitoring. In my brief times meeting with Mr. Moa, he's expressed his concern for his significant other, the child he has that's, going to soon be born. And hopefully that spurs him to, do whatever he needs to do to overcome the substance abuse issues that have, derailed a lot of his life so far. He's seemed to be a pleasant man because I've obviously met with him when he's, sober, not under the influence of anything. And he seems like a man who can be a positive member of his community. But if he doesn't take advantage of this opportunity to, deal with his substance abuse issues, the number of prior convictions he has, means that he could end up going away for a longer period of time in the future. And the agreement gives him a chance to, if the court follows it, to demonstrate to the court and, more important, his family, his mother, his significant other, and his soon to be born child, that he can, be the man that they all deserve. And it does have a little bit of, conditional jail, the 62 days, it's not a ton, but it's at least a little something just to say that, you have to at least serve some modest amount of jail time just to even get probation for this, because otherwise it, with all the factors in there, wouldn't normally just be a pure probation case without any sort of upfront time. And I think this state, in making the offer and Mr. Moen accepting it, the focus is on showing that hopefully Mr. Moen with his forthcoming child has that extra motivation to, get on the right path and stay on it. And I would urge the court to adopt that agreement so that Mr. Moen can, try and prove to his family and himself that he can be a valuable member of the community and there for his family. Thank you, Your Honor.
Thank you. Before I ask if you want a statement, you wanted to tell me anything, Mr. Moa, you don't have to tell me anything, but if you want to, I want to know, what will it take to get your driver's license? Have you looked into that?
Yeah, I think it was my driving assessment up in it was the healthcare center in Wausau.
What's been stopping you?
I tell you the truth, I got no excuse for it, just running around having fun with friends.
Can we change that?
Yeah, we go, especially with my kid on the way, and I want to change.
Get a dad that can drive.
Oh yeah, definitely. And I've been talking to Pastor Jack, and he said that he's willing to take me under his wing and move me to a different environment where he could help me out a lot. The time that I've been here, I've been going to parenting class. I got at least 6 hours, 6 or 7 hours entry, been attending NA, stuff. So
That's good to hear. Anything else you want me to know?
I'm sorry of what I did. So
I am concerned about the crime that you pled to, the taking and the driving of the vehicle. That's your mother's vehicle. Yep, it's family. Yep, it's your mother. You still have zero right to take her vehicle without her consent or to keep it longer than she agreed to let you keep it. So that is serious, especially it's a felony. You're being responsible and you're taking accountability and you're saying, you know what, I understand I did this. I shouldn't have done this. What is more concerning to the court is that other charge that was dismissed and read in that possession of methamphetamine as it weighed with the bagging and whatnot, about 18 grams. That's a lot of methamphetamine. That tells me that there is a substance abuse issue, problem that needs to be addressed. You're admitting that there is one that needs to be addressed. I won't say too much about what your significant other, Ms. Stevens, has said because her case is not yet resolved. But that's what scares me. That's a lot of methamphetamine. You're going to be a dad.
Yes.
For the first time.
I know.
It's amazing. It's a great experience. You get to raise and to bring up this child who will be and do what you do and will follow in your footsteps and want to be just like dad. Okay. And 25 convictions or so that you have under your belt. I don't think you're proud of that. And seeing you sit in that orange, think about your child. I don't think one day you want to see, little angel, girl or boy, could be either girl or boy as angel, sitting in that table in orange. I don't think you want that. And in order to be able to try and circumvent that and stop that from happening, you have to take control of your life. You have to take control. You have to want it. And I'm not saying it's easy. It's not going to be easy. It is hard every single day. I see people struggle every single day, but I also see people do it. And they say, I am done. My life means more to me than the devil drug methamphetamine. So you are the only one who can do that and who can take control of your life. I want to let you know,
Sure.
Ms. Stevens is doing well. She looks great. She looks good. Baby looks healthy in her little belly. Got to see her yesterday. All right.
Good.
So you have something to look forward to improving your life and to doing better and being better. Because if you're not, who's going to be there for your baby? Who is?
Nobody.
And you have to be there because you have to be strong to help Miss Stevens be strong. You both have to be there together. Okay?
Okay.
So this is serious because of all of those things. You are accepting that responsibility and being accountable, and you are indicating that you are stipulating to the $847 in restitution, correct?
Correct.
And again, off the record, I told you the only way that you'll stop seeing me is if that's paid off in full, or if you pay off your mother and she writes the DA's office and lets the court know that that's taken care of. But she has to work with the victim witness coordinator and with the district attorney's office with that. So I'm hoping, I don't know your relationship with your mother, I'm hoping that you can mend fences, especially because she's going to be a grandma.
I know.
So you have a lot of inner reflection to do, and you have a lot of apologizing to do.
Okay.
Right? I don't think that the community is at risk or harm for you. This seems like it's a self-use. If there's any hint at dealing or selling, I'm going to tell you, stop right now. You will go to prison. and I want you to be a dad.
Okay.
All right? I
All right.
want you to be a dad. Nothing is worth risking not being with your child. I'm going to follow the recommendation as it relates to probation. 2 years of probation, that'll just go concurrently with the probation you're on right now. I'm not doing a withheld sentence. I'm not seeing this as a prison sentence. I don't know. I'm going to guess you've never been to prison before.
I have.
You have? For what?
For revocation,
What was the charge?
it was for possession of a firearm.
Okay. As a felon?
Yeah.
Okay, but you didn't go to prison for any other felony? Just that one?
That one in bail jumping. That's about it.
Okay. Well, I don't think that this is a prison case. I don't know if your mom wants you to go to prison. I don't have any impact statement to tell me anything of how seriously this impacted her and what she feels. But based upon these facts and what I'm sentencing you for, this isn't a prison case. So I'm going to sentence you to 9 months of jail, imposed but stayed. You're going to be on probation. You're going to be given that chance. I'm going to put certain conditions on you. And if you decide I'm not going to take control of my life and I'm just going to let methamphetamine do that for me, you will be revoked and you will go and sit this 9 months. Okay.
Okay.
And this is going to be 9 months consecutive to any other sentence you sit. So that's the thing, that's that hammer over your head. So if you get sentenced on this Marathon County one, no matter what the sentence is, this is attached. It doesn't run the same concurrently. It's separately.
Yes.
So that's the hammer over your head. I want to give you a hammer because I want you to be the best angel you can be. All right.
I will.
The best dad that you can be. Okay.
Okay.
Conditions are, conditions on probation, absolute sobriety, regular drug testing, no use or possession of illegal drugs, substances, or paraphernalia. I'm ordering that you get your driver's license. Okay.
All right.
Because you need it, and I want you to have that.
Okay.
And I'm going to tell you, that's probably the precursor of what has started sending you and getting other charges, because you get pulled over for not having your driver's license. Get your driver's license.
I will.
Okay.
Okay.
I'm going to do an AODA assessment and treatment evaluation. Okay.
Okay.
I don't know if you've been to treatment, and I don't, if you have and it hasn't worked, sometimes it doesn't work the first time. Sometimes it doesn't work the second time, but you have to want it. You have to really, really want it.
Yes.
And Miss Stevens is in treatment. I want you both to be the best versions of you that you can be, so you can be the best parents that you can be. I'm ordering the $847 in restitution to be paid to PV, 62 days of jail credit. I think that's all. Gainful employment or additional schooling. So I don't know if you're looking at going into a trade, or you're looking at doing some type of going additional schooling, secondary schooling, but either gainful employment, treatment, or secondary schooling. Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. $518 in fines and fees for the conviction. I'm going to set up a payment plan, $50 a month until paid off in full. You pay our clerk. Well, I'm gonna have you pay our clerk, because that's more of an accountability, because I look at that, and if you miss a payment, I can issue a warrant, and that's separate from your probation warrants. Okay?
Okay.
Because again, that's that other hammer, because I want you to do it this time. Okay?
Okay.
So $50 a month, and the payments will start, I'll start January 2026, so you have some time to
Okay.
figure out what you're gonna do.
Okay.
So you're gonna pay our clerk, not probation. Our clerk, not probation.
Okay.
Yes?
Just to clarify on
Oh, we have to do restitution. Never mind. So I can't. It has to go to probation because of the $847. So I have to send it to probation because of the restitution, because that needs to be paid off first. So whatever you're going to do with probation, or with restitution, that it has to be taken care of first,
Okay.
and then the court costs and fees. So with restitution,
Probation will be collecting
yes,
restitution.
probation is collecting it. And this is probably one where we're gonna have you in restitution court. And that wouldn't be the first time. We have one hearing on, our first on January 6th, but we're not going to, I won't need to see you that early. Let me just set right now. And you can appear by video at the next one, because I'm not sure if you're going back to Marathon, or I'm not sure where you're gonna be.
Okay.
So April 13th at 2:30. April 13th at 2:30, that's restitution court. That's where you're gonna update me on the payments you've made, if you've already paid her, and how there's proof, whatever's happening there, because you're gonna have to show that you've made payments. And with that restitution, unfortunately, I have to increase it to $100 a month, because that has to be paid off, and paid off more quickly. If you're having a significant and substantial financial hardship, you need to write the court, and you need to tell me at that hearing. But at that hearing with restitution court, you could have additional days in jail if you're not making your payments. Okay?
Okay.
Very important you figure that out.
Okay.
All right? April 13th at 2:30.
And the rest of my hand is hard to read.
Yes, sir.
Court costs and fees come completely after you pay off that restitution. I need your DNA. The jail makes sure that they get that. You can look to see if you can request it be expunged through the system, from the system through a written letter to the Department of Justice. Ask your attorney or Google it. It's pretty easy to do. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Mr. Schmidt, what am I missing?
Nothing for me.
Mr. Keen,
Nothing here, Your Honor.
good luck, Mr. Moore.
Thank you.